Hi, my name is amish.aggarwala. I'm an advocate practicing in Delhi and I wanted to make a quick little video. I just read that Mehul Choksi, the allegedly runaway billionaire, millionaire, whatever it is, filed a writ petition in the Delhi High Court saying that this Netflix documentary Bad Billionaire Boys or Bad Boys Billionaire, one of these things, is streaming on Netflix with his face on the poster. And in that writ petition, he wanted that before the release, in the pre-screening, he should also be allowed to watch what is mentioned in the movie with the apprehension that it will be prejudicial to his case, to his trial in the future. The Delhi High Court observed, and to my mind rightly so, that in this particular case a civil suit would be the proper remedy for Mehul Choksi and not a writ petition. To give a little background, writ petitions are filed under Article 32 of the Constitution, either directly before the Supreme Court of India or under Article 2 to 6 of the Constitution before any of the high courts which have jurisdiction over the area where the cause of action has arisen. Now, in this particular case, Mehul Choksi felt that a writ petition would be the more proper remedy. I assume because there are certain arguments that people make that right to privacy under Article 21 has been declared to be a fundamental right by the judgment of Justice K.S. Puttaswamy, and because of that perhaps they want to seek their enforcement. But one fundamental aspect of writ law and the law of approaching the Supreme Court or the High Courts under a writ remedy is to see whether the fundamental rights that are being infringed, are they being infringed by the state or by an individual. This is one example. Another example with a little bit of a difference, which was in my case itself, will perhaps give a little better explanation as to what I'm talking about. Now, what happened was last year a gentleman came to me and told me that he wants to be a cabin crew with an airline in India, and he being an overseas citizen of India, so therefore an OCI card holder living in the US, wanted to be a cabin crew in India. I never understood his reasoning. He said he wanted to come and connect with his roots. So anyways, he comes to India, he interviews with this one company for their training academy, and the company refuses him solely on the basis of him being an OCI. And when he asks why is there a distinction, because apparently the only distinction is that OCI people cannot hold government positions in India, but otherwise they are entitled to private jobs being overseas citizens of India. The reasoning given by the company was that the DGCA, which is the Directorate General of Civil Aviation, has mandated to all the airlines that you cannot have non-Indian nationals as either pilots or cabin crew. Now, this gentleman went to the DGCA, asked the officials over there. The DGCA said there is no such rule or regulation. The difficulty that this gentleman was now facing was, how do I reconcile between this whole aspect of, on one hand, the DGCA saying that there is no such regulation, and the company saying that we are relying upon the regulations of the DGCA. When he approached me, he wanted me to send a legal notice to the company. I did that. They did not respond at all. He asked me the next course of action, and I said that there is perhaps a 5 or a 10% chance that this writ petition might get dismissed. But the reasoning for filing a writ petition was that the DGCA is in control of these airlines, is at least the statutory body governing the regulations, the conduct of these airlines. And if they are doing something bad, it is the DGCA which is supposed to punish these airlines for defaults. We looked up the requisite provisions in the relevant act. I don't remember the name now, and we said that yes, the DGCA has the authority to penalize this airline for giving this kind of a statement. And so if we write to the DGCA and the DGCA does not do anything in this particular situation, then a writ petition is maintainable against the DGCA. And from the past conduct of the DGCA, from whatever my client had told me, I knew that the DGCA would not do anything if we straight away write to them. So the strategy here was, we approached the DGCA. Of course, they're not going to do anything. Then we file the writ petition in the High Court and we get the remedy from the High Court and go to the High Court and say, we are seeking a remedy against DGCA because the DGCA is supposed to take action against this particular airline, but because the DGCA is not doing it, this airline is able to discriminate against me so openly. So we filed a representation with the DGCA. To our surprise, the DGCA, especially now understanding the legal language, understanding the statutory provisions, and understanding that in all likelihood we are going to end up before the Honorable Delhi High Court within the next, say, 1 or 2 weeks, the DGCA itself pulled up the airline by the collar, told them that they cannot discriminate against my client like this, and directed an interview. Now, unfortunately, one twist after the other, the lockdown happened immediately and nothing has happened so far. But this particular news article that I read about Mehul Choksi's writ petition being dismissed with the observation that a civil suit is the only remedy reminded me of the situation that I faced just a few months ago, where my first instinct was to say, file a civil suit for discrimination. But we all understand, and perhaps this is the reason why Mehul Choksi also wanted to approach the High Court, was because civil suits, they take much more time, usually, for the matter to proceed. Of course, there is the provision of Order 39, Rule 1 and 2, saying that if there is supposed to be some damage which cannot be rectified at a later stage, then in that, which is called irreparable harm. So if that is going to happen, then the court can issue notice immediately within maybe, say, a few hours, maybe a day or two. If notice is served upon the other side, they must come. And in the meanwhile, or perhaps if there is some grave urgency, ex parte, that is without information to the other side, injunction, that is any direction to do or to not do something, can also be granted by a civil court. However, most civil courts are also very, very reserved when it comes to passing orders like this, and that is why perhaps Mehul Choksi thought that he will give it a shot with the High Court first rather than going to the district courts. In all likelihood, if a civil suit would have been filed, notice would have been issued even in this lockdown time, and perhaps in a day or two the matter would have reached a hearing, and perhaps the civil court would have effectively put that choke on Netflix, and Mehul Choksi could have at least gotten that right of screening. On a side note, another argument was made that Choksi is an absconder evading the process of justice, and therefore he should not be granted any sort of relief at all. I do not know whether the court, because I've not even read the order till now, I don't know whether the court has ruled on that aspect or not, but to my mind, without the person being found guilty on a preliminary stage, it is very, very, of course, counsels are going to make their arguments, but at a preliminary stage, it would be very, very improper to not allow the writ petition of a person just because maybe he is accused of an offence. My mind is drawn to the cases of custodial torture in which I believe D.K. Basu and a couple of other people filed their petitions. Now, for the state to come and say that this particular ABCD person is a convict, is convicted of a heinous offence, so in that kind of a situation, he should not be given any right to approach any court for redressal of any grievance. Seems very, very misplaced to me. That is also another aspect that we consider from time to time. If you're accused maybe of a very, very grave offence, or if you are perhaps, if you are accused, if you are convicted, does not mean that your rights to life, liberty, all of those other things that Mehul Choksi approached the court for, right? There is some common examples are Article 14, right to equality, Article 19, certain freedoms are there, Article 21, which is super important, which is right to life and liberty, and equally important, Article 22, right against arrest and detention. They are all, without due process, that is. They're all very, very important. They are the fundamental, the foundational tenets of what a democracy is and should not be taken lightly. That is all for today. Again, I thought I'll make a quick video, but it turned out to be a little too long. I I hope you like this one. If you did, please and subscribe and whatever. Until next time.